Getting a grasp on the legal and political landscape at the state level is key to understanding the impact of last month's decision. To help us get a handle on what's going on, we're joined by constitutional scholar and appellate attorney Adam White. He's a senior fellow at the American Enterprise Institute and served on the Presidential Commission on the Supreme Court. Welcome back, Adam. It's so great to have you here to explain all of these intricacies. President Biden directed HHS this morning to protect abortion access in an executive order. What kind of power does this really have? Are executive orders symbolic?
Well, they're more than symbolic. An executive order, while it can't trump the Constitution or federal statutes, it can direct agencies to exercise discretion in certain ways up to the limits of the statutes and the Constitution. So we'll soon see to what extent President Biden's executive order does bump into statutes of the Constitution. But right off the bat, I just want to point out he's ordering HHS to consider which actions it could take under the Affordable Care Act and other statutes to expand access to abortion. For all the talk after the Dobbs decision that this would return the issues to the states, and that's true, those of us who focus a lot on the administrative state knew that it was only a matter of time and probably not much time until the Biden administration would try to route all these issues first and foremost back to the administrative state. And so here we are.
And so just to give a little background, Adam, the federal government can't create a right to abortion through an executive order, but they can tell all of the government agencies to get involved in abortion access. Is that right?
That's right. And of course, the tale of the Affordable Care Act from its very enactment has been an effort over and over again by first the Obama administration and now the Biden administration to stretch its meaning, to expand provision of contraception or abortion to women. And now we'll see that again. We'll see it stretch the meaning of statutes and probably bump up against sovereign powers of the states and private rights of individuals.
Well, we'll have to see how that plays out. Adam, can you explain what states can and can't do now that Roe and Casey are overturned?
Well, now that Roe and Casey are overturned, of course, the states have the primary authority to legislate on questions of abortion. Now, states cannot violate the U.S. Constitution, and so there will be some interesting arguments, and Justice Kavanaugh alluded to some of them about in his concurrence in Dobbs, interesting arguments about whether a right to travel among states, part of the Interstate Commerce Clause, whether that would trump a state's own power to limit people's right to exit the state for purposes of getting an abortion. So we'll see that. We'll also see interesting claims under state constitutions, arguing that actually the state constitutions limit what the state legislatures can do.
That's a lot there that we have to unpack. Our viewers know that some states have trigger laws. They've heard us talk about trigger laws or pre-existing laws that protected life in certain states. Under what grounds or using what reasoning are those laws being stopped by state courts or stopped in that process of litigation?
Well, we'll see at least three grounds raised. I don't know how much any of them really actually carries weight, but we'll see these litigated. First, we'll see plaintiffs invoke state bills of rights, probably provisions similar to the federal Bill of Rights. And while they failed in Dobbs to persuade the U.S. Supreme Court that, say, the 14th Amendment protects a right to an abortion, you'll see similar arguments made under state constitutions hoping for different results. You're also seeing arguments that the state's laws restricting abortion are unconstitutionally vague. Ironically, the kind of argument that conservatives are making against federal administrative agencies now, often with great criticism from the left, you'll now see progressives make exactly the same kind of argument against state abortion laws, saying that they're insufficiently precise and explicit to really define people's rights and obligations. And finally, you'll see arguments about the state's separation of powers, particularly in states where the trigger laws vest a right of private action, a private cause of action for individuals to file their own lawsuits limiting abortion.
Well, the last abortion clinic in Mississippi closed its doors this week, prompting the discussion about cross-state abortion access, which you just talked about. Is there anything states can do to actually limit that?
This is actually, I think, a legitimate argument and one that Justice Kavanaugh raised. The Constitution, its protection of interstate commerce and the free flow of goods and people from one state to another has long been construed broadly to really limit what states can do to limit their own people from exiting or entering the state. And so this is a very serious constitutional argument that critics and opponents of abortion will need to take seriously.
So if they are going to take that argument seriously, seriously then is what Colorado's governor did. Jared Polis, he recently issued an executive order saying in part that he would decline requests for the arrest, surrender, or extradition of any person charged with a criminal violation of a law in another state where the violation involves reproductive health care, meaning performing or getting abortions. Is this order enforceable then?
I'm glad you brought this up because this is going to be a huge point, not just in Colorado, but in states like Wisconsin, where the governor said he might grant clemency to people who violate that state's pre-existing abortion laws. Governors are going to invoke both provisions of their state constitutions and provisions of the federal constitution and assert that those provisions limit their own legislatures or other legislatures' powers to regulate abortion. So this is going to be sort of the tip of the argument, and you'll see a lot of state governors going far beyond what I think we could expect federal or even state courts to actually say the content of the constitutions contain.
That's an interesting point and one we're going to have to watch. Let's get into court packing. You served on the Presidential Commission on the Supreme Court, which explored ways the powers of the court could be reformed or limited or expanded. The Roe ruling has revived these discussions, and some of the other members of your commission are calling for seats to be added to the court. Do these claims have legs?
Well, no, of course not. These are not new claims. First of all, my former colleagues who are now making this argument, Professors Larry Tribe and Nancy Gertner from the Harvard Law School, they were making these arguments in December when our commission ended. The commission had a very broad and vigorous debate over court packing. We did not endorse court packing. I was glad to see that. And I think if we had endorsed court packing, it would have been a disaster. We're now seeing those same arguments coming forward simply out of my former colleagues' dissatisfaction that the Supreme Court no longer conjures rights the way it used to.
And we are seeing arguments around a political solution there and getting rid of the filibuster. Do you think that that's feasible?
No, not in the current Senate. There's no appetite for it among the key senators in the Democratic Party, Senators Manchin and Sinema, as well as, to say, of course, the Republicans. I do not expect this to change. And I think Democrats ought to tread very, very lightly here. The last time they played around with the filibuster, they opened the door to an entire generation of judicial appointments and Supreme Court appointments. And if they reduce the filibuster for the sake of increasing access to abortion, they may soon find future Congresses using the same majority rules to legislate on abortion in the other direction.
Well, that's an interesting point, and Adam, we'll be watching that closely and the midterms as well. Thank you so much for explaining this to us.
Thanks, Montse.